the use of that is discussed in a January 2016, they're called memorandum opinion by the West Virginia Supreme Court. That's the only place I could see it mentioned. State versus Rogers. Opinion number is 14-0373, 215 Westlaw 869-323. But it essentially says that the risk and needs assessments are provided for under West Virginia Code 62-12-6A2, and the purpose of this, the memorandum opinion, was to make it clear that these assessments are merely a tool that may be used by circuit judges during sentencing. So it's not required that the court consider it, and the court is not going to consider the LSCMI evaluation for either this case or the other case. In the official version, there was objection to that. I'm not going to consider the official version in this case because I heard the evidence, and I don't know. I mean, I didn't read the official version even before there was an objection because I heard the evidence, and that's just my practice. When I have a jury trial and I hear the evidence, I base a verdict on the evidence that I hear at trial, not about what may be included in the official version, because it's my understanding the official version generally comes from police reports, which may or may not be what the evidence is. So I did not consider the official version in imposing sentence in this case. In terms of the pre-sentence report from 11F101, there was something I think on the cover page about not knowingly, willingly, or intelligently when there's a plea guilty. We discussed this previously, that certainly the defendant can maintain that, but it's this court's opinion that if the defendant wants to in any way pursue that as some kind of a collateral attack on that guilty plea in 11F101, that the defendant would bear the burden of introducing evidence to that effect. And there's been no evidence presented to that effect. And so, certainly he can say that, but the court doesn't believe the court doesn't believe that I have to rule on that because, in my opinion, it's not really been raised. All the remainder of the corrections or comments to the earlier pre-sentence report, one can make an argument, and it would have, in my opinion, good weight, is the weight, it's been weighed, because we had a hearing in 11F101. We gave the defendant the opportunity to make comments, objections to the pre-sentence report. He was represented by counsel, and it was stated on the record at that point that, at least my recollection is, that there weren't any corrections or additions. But whatever corrections or additions were made were dealt with at that time, and the sentence was imposed. But what corrections and additions and comments were made to that earlier pre-sentence report, again, would not affect the sentence in this case. They're, I don't know how to characterize, maybe clerical, but it certainly does not, in this court's opinion, affect the sentence that will be imposed in this case. The court reporter is to transcribe a portion of this hearing showing the defendant's objections and the court's ruling. And that transcript shall be provided to the probation officer, who shall attach the transcript to the pre-sentence report so that the objections and the court's ruling on the objections and comments can follow the pre-sentence report. All right. Now, there has been a motion filed by the defendant. Style, demand, and prayer for post-verdict judgment of acquittal or in the alternative for a new trial. And so the court would, of course, treat that as a motion for judgment of acquittal, post for a new trial under rule, under criminal rules. Mr. Deegan, is there anything else you want to add or any evidence you want to present on your motion for judgment of acquittal or motion for new trial?
No, I mean, everything was clear on the record from the trial. I stated everything that I thought needed to be stated within it. I never did receive a response from the state so that I could see if I needed anything. I mean, this was something that was drafted mainly by a bar attorney, and so I figured that it would have at least gotten a response from the state so that I would know what their argument was, notice, and I haven't received anything. So I didn't think that anything needed to be entered other than it itself.
Mr. Rogers, anything you want to say with regard to the motion for judgment of acquittal or motion for new trial?
Yes, Your Honor. I'll take up the issues that Mr. Deegan brought in this motion. First, it appears to me that the view that Mr. Deegan has is he states that this threat was not communicated as required. Well, I think it was clear in the evidence that we heard during the trial that it was absolutely communicated. We heard it. We heard it on the conference call. The jury heard this communication of these terroristic threats. It was communicated to this larger audience over this conference call. It was also communicated over the internet, where the defendant and his group hosted this conference call, and it was communicated through interviews that we heard these threats that the defendant wished to take over the government, and we heard those interviews as well. So I believe that these terroristic threats were absolutely communicated. The defendant also has an issue with the fact that he states that the victim didn't take his name. This is a crime against the state of West Virginia. The defendant wanted to take over the state's government. We heard from the West Virginia State Police who investigated this crime. We also heard from the Fusion Center and the Wood County Home Department Office. We had more than enough evidence through them, as well as the audio and video that we heard, to prove this case to the jury, and I think that's shown with their verdict. The questions of constitutionality of the charge, the defendant states that it is protected speech under the Constitution. This has been ruled on. The West Virginia State Court, or the Supreme Court, has ruled on this issue, and State v. Deegan, you can't just make terroristic threats that will could result in serious bodily injury. And the Supreme Court stated you can't So I don't believe that's a valid issue. The defendant brings up jurisdiction issues and presumption and political jurisdiction issues. Jurisdiction issues were ruled on and ruled on prior to the trial, and the state did prove jurisdiction in the case. The defendant had an issue with the home confinement office taking the stand. This issue was addressed prior to the trial, and the state informed the court that it needed to present this evidence to show where the defendant was at the time this conference call was taking place, and the court's already ruled on that issue. The defendant also has an issue with recordings, the telephone calls, and states that these were downloaded from the internet without a lawful warrant. These were in a public place. These were on YouTube and open forums where anybody could go on the internet where a warrant was not needed. The defendant has an issue with not getting a continuance of the trial because he states late disclosure of evidence. Again, this was addressed prior to trial. The defendant had an opportunity to have this evidence well before trial. He chose not to get this evidence through his attorney that was appointed, Mr. Oshaway. He chose not to work with Mr. Oshaway, and the state made every possible concession, if you will. We bent over backwards to get this information to the defendant. The court bent over backwards and talking to the Supreme Court to get this evidence to the defendant. And again, we addressed this, and I think the defendant had more than enough time to prepare his case. The defendant has an issue with the fact that he states that the court didn't inform the jury of the four prohibited consequences as set out in the code. I believe that the code which he was charged under, where it states that these terroristic threats must be intended to one of four things: intimidate or force civilian population, influence policy, affect the conduct or branch of government, or retaliate against the branch of government. These were part of the jury instruction that was actually approved by the defendant. These were part of the jury instructions that went to the jury. They were informed of these four issues in the code, and the state actually went over these four, as the defendant states, prohibited consequences are set out in the code as well. The defendant has an issue with the court denying the demand for a directed verdict of acquittal, but I think it's clear the state has presented more than enough evidence for a jury to get evidence back and come back with a verdict of guilty. And it went over each of those elements at that time, at the time that the motion was made. I believe that's the issues that the defendant has addressed. For those reasons, I don't believe any of these issues have merit. They have been addressed. And I would ask the court to dismiss this motion.
Deegan, you want to say in response to anything that the prosecutor said?
Well, I was having trouble following him, going quite in order there. And of course, his spin on everything is very nice. I think that yes, it would have been number. Let's see, protected speech. First article of amendment, as well as the Constitution of West Virginia. It does clearly state it shall not be abridged